One really interesting, but also kind of sad fact is when a case goes to trial, as in it's been filed in a court of law and goes all the way up to jury selection and trial, what most people don't know, and by default, because of that, what most jurors don't know is that insurance cannot be mentioned at trial. It cannot be mentioned during jury selection. It can't be mentioned during the duration of the trial. There isn't even a rule that's given to jurors on how to deal with insurance. It's just not mentioned. And that's a really, really interesting thing and also sad fact because most insurance companies are wealthy. Okay. They make their money by not paying out claims, which is generally how and why most cases go to trial here in Texas. It came to a point where they were still refusing to sell a claim based on the fact pattern or, other factors that they've taken into consideration. And so jurors, when they're sitting there in trial, don't realize that it's not the defendant that is actually paying the damages for our client. It is actually the big insurance company. We are just not allowed to mention that fact. That is a very specific rule in the rules of evidence that we have to follow, specifically Rule 411. And what it means is, knowing that, a juror is probably going to try to lower what they would award a plaintiff because they don't want the defendant holding the bag for that amount. And this is really important because, the Texas insurance lobby, the national insurance lobby is doing the work. They want to make sure that jurors and regular folks don't know that you can't mention insurance at trial and that it is in fact the insurance company that is going to be paying damages.